Welcome to AITV News. This summer, tens of thousands of federal government workers are facing the possibility of losing their jobs. In this explainer, we'll break down a recent Supreme Court ruling that set these potential mass firings in motion, what it means, and who is affected. The story begins with a major decision from the United States Supreme Court. In an 8-1 ruling, the court gave the Trump administration the green light to proceed with plans for widespread layoffs across the federal government. The court did this by lifting a nationwide injunction, which is a type of court order that can halt a government policy across the entire country, that had previously blocked the firings. This allows the administration to immediately move forward with a February 11th executive order. That order directed federal agencies to prepare for what are called large-scale reductions in force. A reduction in force, or RIF, is the official term for a layoff process within the government, often used to downsize or reorganize. This particular plan is part of a broader initiative from the Department of Government Efficiency, aimed at what the administration calls eliminating waste and bloat in government. The plan was quickly challenged in court. A coalition of federal unions and other groups sued, arguing that the president was bypassing Congress, which they say has the ultimate authority over reorganizing federal agencies. A federal judge in California initially agreed with them and issued a preliminary injunction in May, which is a temporary order to maintain the status quo that halted the layoffs at 22 agencies. That is the order the Supreme Court has now lifted. It's important to understand exactly what the Supreme Court's ruling does and does not do. The court said the administration is likely to succeed in its argument that the executive order itself is a lawful exercise of presidential power. This means the process of planning and initiating layoffs can resume. However, the court explicitly stated it was not ruling on the legality of any specific agency's layoff plan. Those individual plans can still be challenged in lower courts. Justice Ketanji Brown Jackson was the only one to formally disagree with the majority's decision, writing a dissent. In it, she argued the court was allowing an unprecedented and congressionally unsanctioned dismantling of the federal government. So, what is the immediate impact? At least 17 federal agencies are now free to proceed with 40 separate layoff plans that were already in place. These agencies include the Departments of Agriculture, Commerce, Energy, Labor, and Veterans Affairs, as well as the Environmental Protection Agency and the Social Security Administration. The State Department, led by Secretary Marco Rubio, has already confirmed it is moving forward immediately. Furthermore, the administration is seeking to shorten the standard 60-day notification period for affected employees to as little as 30 days. However, the legal fight is not completely over. Several agencies are still protected by separate court injunctions that were not part of this Supreme Court case. For now, large-scale layoffs are still blocked at the Department of Health and Human Services, the Department of Education, AmeriCorps, and the Consumer Financial Protection Bureau. For now, there is widespread anxiety among many federal employees. Unions have vowed to continue fighting the layoffs on an agency-by-agency basis in the lower courts. The White House praised the ruling and has stated it will resume the termination process immediately. The Supreme Court's decision has opened the door for significant changes to the federal workforce, but the legal and political battles over how and if these mass firings will ultimately happen are far from over.